Welcome back. Now, the NPA is approaching the Supreme Court of Appeal after Judge Loubser dismissed its bid to appeal a ruling that the extradition of former Ace Magashule's PA, Moroadi Cholota, was unlawful. Cholota was brought back to South Africa to face charges relating to the Free State Asbestos Removal Project corruption case with over 200 million rand. I'm joined now by NPA spokesperson Mthunzi Mhaga. Mthunzi, thank you so much for joining us this evening. Yet another loss for the NPA in the Cholota matter, as your application for leave to appeal was dismissed yesterday. And as mentioned a little earlier, now you're heading to the Supreme Court of Appeal. Now, considering the apparent repeated losses, what makes the NPA believe that it would be successful in the Supreme Court of Appeal?
I'm not sure when you talk about successive appeals or losses, because this is the first appeal that we've lost in respect of the matter that relates to Ms. Cholota. However, we hold the view that the Honorable Judge erred in not reserving the questions of law that we had presented to him. And I need to also mention that the main ground or basis for him to uphold the special plea of lack of jurisdiction, it's based on the SCA ruling or judgment of Schutz, which says that the executive authority is the one that is empowered to make the application. But we are saying that at the time that the decision was delivered, we had already submitted the extradition application. So there are two issues here. That one, we've already applied to the Constitutional Court to appeal the Schutz judgment, albeit on limited grounds of retrospectivity, because we don't believe that the Schutz application would apply in the extradition of Ms. Cholota. We hold the view that therefore there are reasonable prospects of the Supreme Court of Appeal hearing us and ruling in our favor. We also feel that there are compelling reasons why the Supreme Court of Appeal should hear our matter.
Well, the losses being that, you did go to court and you did lose that. You did bring her here and lawfully went back to try and appeal that, and then there was that. But that's just going into semantics and digressing. Speaking about the Schultz matter as well, there was a bit of back and forth as in terms of the timing when it was taken to the Constitutional Court. If we just get clarity for that, when the NPA took that matter to the Con Court.
We applied for leave to appeal, and the Schutz attorneys responded, and we are awaiting the registrar of the Constitutional Court to give us an indication of the directives from the Chief Justice, whether they are prepared to hear us or not. But officially, there is an application to appeal that has been lodged with the Constitutional Court, which is the apex court in the land.
So it will depend on that outcome, the next move for you as the NPA?
Well, when you talk about the next move, I'm not sure, because we can only be guided by the directives of the Chief Justice when we've lodged an application for leave to appeal and the other party has responded. On record, the registrar of the Constitutional Court has given us an indication that the judges are seized with the matter. We will just have to adopt a wait-and-see attitude.
Speaking to the channel yesterday was Cholota's legal team, and they spoke about the repeated concerns again about how the matter has been handled by the NPA, and citing even papers being sent to them late the day before and expected to respond before court closes that day, accusing you as the NPA of basically being a little underhanded in your the way you've engaged and dealt with them. What's your response to that?
Nowhere in the judgment by Loubser J are we found to have acted in an untoward manner. And therefore, I don't think I need to dignify that submission with a response, because we should be confined to the four corners of the judgment that was delivered by the Honorable Judge.
I know you were saying you're not too sure about the next step, but of course the next step in the bigger case overall when it comes to this asbestos case, and of course the co-accused as well. But in this case of Moroadi Cholota, should the Supreme Court rule in your favor, and what would your next step be? To appeal the extradition being unlawful as well, and that ruling too?
If the Supreme Court of Appeal agrees with us it means we will be at liberty to facilitate the re-enrollment of the matter so that she can face the charges together with the other accused persons, because we don't want to adopt a piecemeal approach, because separation of trial, Masa, is very costly and is quite cumbersome and traumatic to the witnesses who would have to testify twice in respect of the same set of facts.
Yeah, and speaking about it being costly as well, there are a lot of sentiments that have been shared around that too. And a lot has been said about this unlawful extradition, especially by legal experts. And the NPA should have known, taking it back, that the powers to sign off on extraditions rests with the executive. I know you've mentioned that you've already lodged that to the Constitutional Court in the Schultz matter, but the back to basics that the legal experts are saying is the NPA should have known that this rested with the executive and this was not a lawful extradition that you were going into.
Let me explain something or clarify something, Masa. And over 89 extradition applications, the practice has been for years that the DPP, in respect of which the jurisdiction falls in that particular prosecution, would make the extradition application. It was only when the Schultz judgment was delivered that then there was an issue of the power to make the initial extradition application. But throughout, that has been the practice. And now it has been pronounced upon. We are saying, let's go to the Constitutional Court and get them to pronounce on retrospectivity so that it does not affect the rest of the extradition applications that have since been made. And I'm repeating to say that when the Schultz judgment was delivered, we had already submitted and the extradition hearing in the United States of America was underway. And on top of that, we have now applied to the Constitutional Court to have that Schultz judgment on retrospectivity ventilated and pronounced upon by the Constitutional Court.
Would you say that this is an attempt by the NPA to try and remove what may look like egg on its face to justify the song and dance that was made about Cholota's extradition?
There's one thing that you should understand. There is a point that we made during the argument in terms of Section 319 on Friday. We said to the Honorable Judge, it is quite unprecedented that you find an extradition order granted by a foreign state or the requested state, then the accused person is extradited to the requesting state. He then does not explore the appeal hierarchy courts within the requested states that granted the extradition order and comes to South Africa to challenge that order. That is one of the arguments that we had raised. So I'm saying to you, it's quite unprecedented. It is also the reason why we also listed that as one of the questions of law that need to be responded to or reserved by the Honorable Judge.
What has been clear is that there are clearly issues in the NPA. There have been bad errors in cases that haven't yielded much success. You know, we talk about Bushiri matter, the Guptas, and when you're talking about extraditions, Omodoso case also comes to mind. But other issues too within the NPA, hence now calls for an inquiry into the NPA as well. We also had the advocate Shamila Batoy saying, further retracting those statements, but referring to those interferences. But admitting, albeit, that there are challenges that are quite monumentous. Is the NPA able to capably function sufficiently amidst all these challenges as well, and what may seem like a lot of balls being dropped?
You mentioned Omotoso. We have asked the Honorable Judge there to clarify factual findings in line with acceptable and reported case law of the Supreme Court of Appeal. Once we succeed in that appeal, we have an extradition treaty with Nigeria and will proceed to apply for his extradition. Bushiri, we won that extradition order in respect of 3 charges. Unfortunately, he has appealed that judgment. A month ago, you guys were applauding us for the successful prosecution of a landmark trafficking in persons for the purpose of exploitation and kidnapping of Jocelyn Smith. Those accused persons have been sentenced to 3 life sentences. 3 weeks ago in Kumga in the Eastern Cape, a former police officer raped a domestic violence complainant inside a police station. He was successfully prosecuted by our prosecutors and was sentenced to 20 years in jail. The statistic sits at 77% in Tutuzela Care Center victim-centric adequate measures in sexual violence cases. Yes, there has been a setback, but you'll recall that even the Nulane Gupta leaked case has now been ordered by the Supreme Court of Appeal to be retried, which demonstrate a prosecutorial strength, capacity, and prowess within the National Prosecuting Authority. So these are isolated incidents. We still have capacity to prosecute effectively the state capture related cases, if one has regard to the fact that during the budget speech vote, Minister Enoch Godongwana delivered a speech to say 14.2 billion has been obtained in freezing orders, 18.2 billion of which has been deposited into the criminal asset recovery account. Yes, these cases are complex and are quite protracted because of the level and quality of defense counsel that are employed by the accused persons. Even tenure of matter in Germany took 3 to 4 years. Let's exercise some patience. We've got this, and we believe that we will sustain the charges in respect of the matters that are enrolled.
And I hear you also mentioning some of your successful cases as well, amidst all these challenges too. But when it comes to the protracted that you mentioned, and also mentioning giving patience to the NPA as well, does it give much patience or inspire much confidence in the public when we're seeing what seems to be repeated balls being dropped in high-profile cases?
I have made it clear that the high-profile case in respect of which there's criticism is the Nulane case that is Gupta leaked according to evidence that we have. We have now been given a lifeline by the Supreme Court of Appeal to retry that matter before a different judge. In respect of Omotoso, yes, we accept it was a devastating and a scathing judgment that actually affected the impact, that had a devastating impact in our fight against sexual violence. We are appealing that judgment because we believe that the judge spent a lot of time addressing the issue of so-called unethical conduct on the part of the prosecutors and the incompetence, but did not take time sufficiently to evaluate the evidence of each state witness that was led. That's why on the 14th of July, we'll be arguing before the Gqeberha High Court, Judge Skuman, for her to clarify factual findings in her judgment, which are not glaring.
Mthunzi Mhaga, thank you so much for your time this evening.